Okay, it should be live on YouTube. And currently everyone is muted. This is the continuation of the case of in the matter of the application of Columbia Gas of Maryland, Inc. for authority to increase rates and charges, case number 9644 before the Public Service Commission of Maryland.
Your Honor, I can't hear you.
Yes, Your Honor, I have just a preliminary matter. We have been gathering up.
Mr. Collins, were you able to hear me just now?
I was able to hear you, yes.
Okay, it must be you, Mr. Alexander. Thank you. Please go ahead.
Just a quick preliminary matter. We have been recording the questions that you've asked of us this morning that we were not able to answer either at all or fully.
Your Honor, I still can't hear anything. I had no problems before, so I've missed everything Carville said and what you said. I don't know what to do.
Is anyone else having technical difficulties hearing Mr. Collins?
I don't hear anything.
Mr. Hoover, can you hear Mr. Collins?
Yes, I can.
Mr. Wilson, can you hear Mr. Collins?
Am I the only one who doesn't hear anything?
I believe you are. So we're going to proceed, Mr. Alexander, while you can try to correct your issue, but your co-counsel is on. My apologies, Mr. Collins. Please proceed.
Thank you, Your Honor. We've been gathering up the questions that you've posed this morning that we were not able to fully respond to. I believe we are prepared to respond to most of them now or whenever you are ready, but we are ready now. And since before we forget all the questions and the answers, we are prepared to go forward. And I would ask Mr. Tubbs to respond to those if that would be appropriate.
Okay. Can I ask you before, I know you want to get to that, as do I, but I want to ask you a question before I forget. There was some mention, at least, of a formal settlement agreement. Mr. Collins, do you know when that will be filed?
I do not know the precise date of filing. I know that it has been circulated to the parties. There are a number of exhibits that have been circulated to the parties. There is still at least one exhibit that is contingent upon the parties' consent to the rate design. From that, we will then be modifying and updating the tariff exhibit to the settlement agreement. So there are a couple of steps here still to be done. My sense is, but I'll let the other parties announce their timeframes, but my sense is we would hope to have everyone's complete review and approval and signatures in the early next week timeframe.
Certainly before the continued hearing on Friday, September 18th.
Certainly, yes.
Okay. Then you can proceed with Mr. Tubbs, who is still under oath from this morning.
Thank you, Your Honor. I'm going to ask Andy just to address what I think is a short list of questions that you posed. We still have not responded to fully. The first question was why the larger 14.6% increase this year as compared to the 2019 increase. The second question is really various questions surrounding the cross-bore and Picaro programs. And third, the ACA involving the $200,000 amortization over 3 years. That would be the third issue on our list. So with that, Andy, may I ask you to address those in that order? Please proceed.
Yeah, thank you. Thank you, Your Honor. Your Honor, you noted and asked me a question at the beginning of the hearing about the percentage of increase from 2019 to 2020. And then I believe I did respond in part that that the $3.7 million in 2019 reflected the impact of the federal government's reduction of the tax rates so the Tax Cut and Job Act. It also dealt with bonus depreciation and the elimination of a bonus depreciation. I think I was a little bit slow in answering because in Pennsylvania this happened, but it was reflected in our 2018 case, not the 2019 case. In Pennsylvania, it's a future test year, and in Maryland, it's a historic test year. So the tax adjustments and the elimination of the bonus depreciation was reflected in Columbia Gas of Maryland's 2019 case because of the historic test year. But I'd say that the 3.7 million in 2019 was sort of the anomaly. If you look at I believe I read off the past history, the company's filings have all been right around that $6 million to $6.5 million revenue requirement request, as we have here in this case. And the second is the cross-bore Picaro. In this case, the company has asked that the commission affirmatively approve 2 deferred regulatory assets. And this would allow us to create a deferred regulatory asset on our books to hang cost up in our books which will allow us to then realize those costs in 2021 for future recovery. As part of the settlement, the company has withdrawn its affirmative request for a deferred regulatory asset relative to Picaro, the leak detection system. So, but the company's committed to going forward with that, but not asking for a deferred regulatory asset. So not asking for that to be addressed in the settlement or in a formal final order from the commission. But the company will report back on its progress with Picaro in the future, consistent with the staff's request in this case. Cross-bore is a little bit different. In 2016, the company started its cross-bore program when it started to identify sewer lines that were infringing upon its system. They literally come through and cut in through our lines, and that's a significant risk on our system, and it's part of our distribution integrity management plan as identified risk. Our current spend to eliminate cross-bores, to identify them and then eliminate them, is in this case in the tune of $81,000. And at the current level of spend that the company has in its cost of service in this case, we will not get to eliminate the cross-bores on our system. It'll take us 94 years to do so. And that's in Mr. Davidson's direct testimony on page 25. By increasing and by asking for the deferred regulatory asset here, we're looking and have asked the commission to provide us with an accounting of additional spend of $75,000. And that additional accelerated spend will take the time it takes to identify and correct cross-bores on our system from a 94-year timeline down to 47 years. So when you say that it's not in the test year, you're correct. But in order for us to actually hang the $75,000 up on our books for recovery, we need an affirmative commission order saying that we're allowed to create that regulatory asset and that we can recover it in a future time. And that will be in our next rate case. And so the $75,000 of additional spend on cross-bores will be subject to in our next case, and would then be subject to full examination by the parties, the judge, and the commission, to whether or not those costs, the $75,000 that we spend, were prudently incurred, and whether or not they were just and reasonable and should be covered in rates. So we're not. It's just allowing us to create the asset to sort of bridge us to accelerate the program. The third item was the $202,000 from the operational orders. And I think the staff witness did a really great job of pointing out that those $202,000 were incurred over a 3-year period. So passing them back over a 3-year period sort of matches with the way that those penalties were incurred. But additionally, if we were to pass back $202,000 in the single PGA case, my concern would be that you would have our customers seeing a reduction in their purchase gas cost for that year to reflect that $202,000, but then turn around the next year and have that gone and then rebound back up to normal levels. So I think that the 3-year amortization of the $202,000 sort of matches the time period in which those costs were incurred, and also reflects sort of a pinball effect of the PGA rates, and may result in some customer confusion. And And I think that's, I apologize.
You or another witness referred to that 202,000 being held in a deferral account.
You had asked us about the time period and why they were hung up, and I got an answer. But Your Honor, I'm going to have Miss Hassan, Bartis Hassan. We'll take, if it's all right with you, with your deference, turn this into a bench data request that we can prepare an answer for to explain the time period in which it was those penalties were sort of captured on our books and the pass back. We'll write it up and then we'll send it to Your Honor, as well as all the parties in this case for review.
Okay, and when you do that, can you also answer another question I have?
Absolutely.
You also are referring to it, and Mr. Carville Collins did as well, as an amortization. Yet I note that the $202,000 is simply divided by 3, and that's the amount that's proposed to be credited over 3 years. Isn't it appropriate to accrue interest at the company's rate of return on that money that the company is holding that belongs to customers?
I'll ask that question if that's something.
Okay. Because I do understand your testimony about the potential pinball effect of giving it all back right away. But then I think the answer would be that it should be accruing a return. But I will look for your answer or Ms. Hassan's answer. I know she's not available today on that issue.
I think that covered the 3 questions. I think the only other thing I would say, Your Honor, is that the company's position is that the settlement term sheet that I walked through at the beginning of the hearing, I think if all the parties were to litigate the case, everybody would stick to the litigated cases, their positions, and the settlement reflects sort of the parties' compromise on those litigated positions to what we all believe to be a good settlement for the customers and the company as a whole. But so I just want to restate the company's commitment to the settlement term sheet that the parties agreed to and have provided to the judge in advance of this proceeding. And we'll get to that the finalized settlement term sheet and accompanying exhibits in advance of the next hearing on the 18th, so you have an opportunity to review it. Thank you, Your Honor.
Thank you. Yes, and I think I said in an email to counsel, but I'll state it again, that if for some reason the parties would like to file written testimony in support of the settlement, they are welcome to do so. I also understand that OPC will likely add a term to the final formal settlement that is, unfortunately, in every settlement that says if every term of the settlement is not accepted, the settlement is off. I assume that's why they're jumping up and down today. What I plan to do is continue this hearing until Friday, September 18th, the date we've already set aside for hearing in this case. If in the interim, the answers that you mentioned being, that are going to be circulated and then I'll review, there's a chance that, then a witness such as Ms. Hassan won't need to be available at that hearing. But between now and then, the formal settlement agreement will hopefully get executed and filed, and then we can have as I said, a continuation of this hearing so that a ruling can be made that OPC will not object to on the settlement. Mr. Collins, does that make sense?
Understood, Your Honor, and that makes sense to us.
Okay. So at this time, I would turn to Mr. Hoover for anything, if OPC has exhibits it would like to have marked and entered into the record at this time.
Your Honor, I understand your ruling, but we have all of our witnesses, the 3 that you had requested, along with the other one that you didn't request, as part of this call, and they are prepared to comment on the term sheet. Notwithstanding our concern and stated objection to the consideration of the settlement process, given how we've gone forward today, our witnesses are here and, as I said, available to comment and respond to your questions regarding the term sheet.
The other witnesses were very helpful in answering various questions I had, so I don't believe I have questions for your witnesses, but you're welcome to have them provide any testimony you would like them to provide at this time.
All right. Well, if you have no particular, no specific questions for our witnesses, I guess I would like to start with Mr. O'Donnell, who is actually involved in a proceeding in North Carolina and has some time constraints. One other issue, like clarification on, we did file rebuttal testimony. I understand that staff did not, and I guess we would look for some guidance on your part as to whether or not to include that as part of this presentation, understanding that staff could file, its rebuttal and the company can file a responsive testimony to that or not.
I haven't reviewed it. It was filed out of time. I don't know if the parties object to it or not. Mr. Collins?
Your Honor, Columbia's position is we don't support the filing of that rebuttal testimony. Our aspiration continues to be that we have a settlement. We do have a settlement in principle and soon to be in writing, we hope. And so we believe that the rebuttal testimony is unnecessary at this time. For that reason, we would not support the filing of it. And at this point, in anticipation of settlement, we do not have a particular plan to file our rebuttal or any response thereto.
Are you objecting to OPC entering its rebuttal testimony into evidence?
I would say that we do object. We don't support that filing, so we would object, yes.
Mr. Wilson?
Yes, as I notified OPC yesterday evening, staff objects to their filing. It was removed from the schedule, the scheduling of rebuttal when the schedule was put on hold, and staff stopped its preparation, and we are also committed to this settlement. So we do object.
Mr. Hoover, I'm going to sustain those objections, and OPC's rebuttal testimony will not become a part of the record at this time.
Okay, thank you. With that, OPC would call Kevin O'Donnell.
Mr. O'Donnell?
Yes, I'm here.
Please raise your right hand. Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Please proceed, Mr. Hoover.
Mr. O'Donnell, will you state your name and business for the record?
Kevin W. O'Donnell. I'm president of Nova Energy Consultants in Cary, North Carolina.
All right. Do you have a document that was filed on September 3rd, 2020, the direct testimony of Kevin W. O'Donnell that contains 90 pages of text?
Yes, I do.
Okay. And do you also have a document?
Fred, so Kevin, would you mind when you're not speaking to mute yourself, because we're getting echoes and it's hard to hear. Thank you.
Okay. With that, Mr. O'Donnell, do you have a document that was filed on August 14th, 2020, titled The Rebuttal Testimony of Kevin W. O'Donnell?
Yes, I do.
All right. Your Honor, I would like the direct testimony of Kevin O'Donnell marked as OPC Exhibit 1.
So marked.
And the rebuttal testimony of Mr. O'Donnell marked as Exhibit 2.
So marked.
Now, Mr. O'Donnell, do you have any, first off, Was this testimony prepared by you or under your supervision?
Yes, it was.
Okay. Do you have any corrections to your testimony that was filed?
No, I do not.
And are the answers to these questions true and accurate to the best of your knowledge?
Yes, they are.
And if you were asked these questions today, would your answers be the same as contained in your pre-filed testimony?
Yes, they would.
And do you adopt these two documents as your sworn testimony in this proceeding?
Yes, I do.
Your Honor, I would move the admission of OPC Exhibits 1 and 2.
Any objections? Hearing no objections, OPC Exhibits 1 and 2 are admitted into the record.
And Mr. O'Donnell is available for any of your questions.
I have no questions for Mr. O'Donnell. Thank you.
Mr. O'Donnell, is there any comment you want to make on the term sheet?
No, I do not have any comments.
Okay, thank you. Your Honor, I guess my next question would be, do you have any questions for any of our witnesses?
I do not.
Okay, fine. With that, I would call Mr. Lafayette Morgan.
Mr. Morgan. I don't see a Mr. Morgan. There, no, that's Mr. Morgan, can you please raise your right hand? Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth? I will unmute you.
Yes, I do.
Thank you. Please proceed.
Mr. Morgan, will you state your name and business for the record?
My name is Lafayette Morgan, Jr. I am a utilities consultant.
Mr. Morgan, do you have a document in front of you labeled Direct Testimony of Lafayette K. Morgan, Jr. that was filed July 24th, 2020?
Yes, I do.
Do you also have a document in front of you that was filed on August 10th, 2020, labeled the Corrected Direct Testimony of Lafayette Morgan, Jr.?
Yes, I do.
And finally, there's just those two. Fine. Was this testimony prepared by you or under your supervision?
Yes.
Okay. Do you have any corrections to your testimony?
None at this time.
And are the answers that you provided in this testimony true and accurate to the best of your knowledge?
Yes.
And if you were asked these questions today, would your answers be the same as contained in your pre-filed testimony?
Yes.
And do you adopt these two documents as your sworn testimony in this proceeding?
Yes.
Your Honor, I would like to mark the direct testimony of Lafayette K. Morgan, filed July 24th, 2020, as OPC Exhibit 3.
So marked.
And the corrected direct testimony of Lafayette K. Morgan, filed on August 10th, as OPC Exhibit 4.
So marked.
And I would move the admission of OPC Exhibits 3 and 4.
Hearing no objection, OPC Exhibits 3 and 4 are entered into the record.
And if you have any questions for Mr. Morgan, he's available.
I appreciate that, but I do not. Thank you, Mr. Morgan.
Okay. With that, OPC would like to call Jerome Mizwar. Not necessarily, I don't.
Mr. Mirzwar?
If you're there, please wave your hand. Oh, there he is. Right.
Okay. And you're unmuted now. Can you please raise your right hand? Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Please proceed, Mr. Hoover.
Mr. Mizwar, will you state your name and business address for the record?
My name is Jerome D. Mirzwa. My business address is Exeter Associates at 10480 Little Patuxent Parkway, Columbia, Maryland.
And do you have a document in front of you labeled the direct testimony of Jerome Mizwar that was filed on July 24th, 2020?
I do.
you also have a document titled Rebuttal Testimony of Jerome Mizwar that was filed on August 16th, 2020.
Yes, I do.
Were these two pieces of testimony prepared by you or under your supervision?
Yes, they were.
Do you have any corrections to your testimony?
Not that I'm aware of.
Are the answers provided in the testimony true and accurate to the best of your knowledge?
Yes, they are.
And if you were asked these questions today, would your answers be the same as contained in your pre-filed testimony?
Yes, they would.
And do you adopt these two documents as your sworn testimony in this proceeding?
Yes, I do.
With that, I would like to mark the direct testimony of Jerome Mizwar as OPC Exhibit 5.
So marked.
And the rebuttal testimony of Jerome Mizwar as OPC Exhibit 6.
So marked.
And I would move for the admission of OPC Exhibits 5 and 6.
Hearing no objection, OPC Exhibits 5 and 6 will be entered into the record.
And Mr. Mizwar is available for any questions you may have for him.
I have no questions for him. Thank you.
Okay, and with that, I will transfer the mic to Mr. Alexander.
Mr. Hoover?
Yes.
When was Mr. Morgan's rebuttal testimony filed?
It was filed on August 14th.
If I may, I did not file rebuttal testimony.
Yeah, I'm not seeing rebuttal of Mr. Morgan. There's only rebuttal of Mr. Merzwa and Mr. O'Donnell.
That is correct.
Actually, I'm sorry about that. That is a mistake I made. So,
just as we did with staff, there will be no OPC Exhibit 4. 4 will be skipped. Okay, let's just put it out there that Mr. Guerin also didn't file a rebuttal. Okay, please proceed. You gonna call Mr. Guerin?
Actually, I'm waiting for Mr. Alexander, who is going to deal with Mr. Guerin.
Okay.
Who I think is back on.
I see Mr. Guerin. Mr. Alexander, did you fix your technical difficulties?
Yes,
you did. Excellent. You can hear us?
Oh yeah, I've been here. Yes, thank you. I had to exit out and then come in again. It's one of those gremlins that I will never understand. I'm just getting my headphones in again. Okay, so I'd like to call Mr. James Guerin to the stand. Your Honor, if you would swear him in, please.
Certainly. Mr. Guerin, can you raise your right hand, please? Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I did.
Thank you.
Okay. Mr. Guerin, would you kindly state your full name for the record?
My name is James Shea Guerin.
And would you please state the name of your business and its address and location?
My business is Snavely King Majoros and Associates. Our business address is P.O. Box 727, Millersville, Maryland 21108.
Would you please state the position that you hold in the business?
As of now, I am vice president.
Congratulations.
Thank you.
Mr. Guerin, do you have before you a document entitled Direct Testimony of James S. Guerin on behalf of the Office of People's Counsel, dated July 24, 2020, that was filed in this case, that is case number 9644?
Yes, I do.
And does that document include 31 pages of narrative testimony, your curriculum vitae, a list of cases in which you testified, and exhibit JSG number 1, which we will return to in a second?
Yes.
Okay. Your Honor, I respectfully request that Mr. Guerin's direct testimony be marked for identification as OPC Exhibit 7. Right?
So marked. Unless you want to take 4.
Well, No, because we may add one or two things. Thank you. Okay. Mr. Garin, was this testimony before you, prepared by you, or under your supervision and direction? Did I lose something?
Just Mr. Garin.
Oh, you can hear me, right?
I can hear you, but Mr. Garin seems to have gone away.
There, he's back. I'm going to repeat that question. Mr. Garin, was this testimony before you, prepared by you, or under your supervision and direction? James, can you hear? James, can you hear? I think that's frozen.
Yes, due to low bandwidth or local computer conditions. Oh, maybe he's coming. No. His video is gone. Mr. Alexander, counsel for the other parties will correct me if I'm wrong, but it's possible they would stipulate to the entry of his testimony.
Okay, and I have here's two corrections to make.
Yeah,
Well, I can just do one now, because James, you're still frozen, right? Yeah, he doesn't realize that he's frozen. I don't know how to get to him. All right, but let me say this. One of them is I sent to everyone yesterday JSG-1 Exhibit 1. That was omitted unintentionally from his testimony. We don't think that it will make any difference. The more important one is Schedule 2, which is there. But we would like to know if anybody has objections to us admitting into evidence, along with his direct, the JSG number 1, Schedule 1, which we sent by email to everybody yesterday evening.
Mr. Collins?
Your Honor, we'd be prepared to stipulate to Mr. Garin's testimony, and we did receive and review Mr. Alexander's notice about the one change yesterday. Unless other Columbia Counsel has any concern, we would stipulate to that testimony.
Mr. Wilson, are you still with
Yeah,
us?
I am. Staff has no objection to the admission of the omitted document.
How about
Okay.
the testimony in general?
So now that we have James back,
We
right?
stipulate to the testimony as well.
Sorry.
Yes.
Okay. Did you catch that, Mr. Alexander?
Yes,
we would
I
stipulate
did.
to the entry of the testimony, including your correct exhibit you filed yesterday.
Thank you. I have James, can you hear me, or are you frozen again?
Hopefully I am here.
Okay. There's one other thing that came up in discovery from a question, I believe, well, it's from either staff or that James realized there was a correction that he had to make in his direct testimony. Is that correct?
Yes, and I can tell you that it was in response to company data request 3 part A.
And can you state what you're correcting?
Yes, at page 29, lines 20 through 23 of my testimony, I make the following statement, in quotes, "In fact, the primary rationale is that the customer payments for estimated future net salvage represent a loan to the company from ratepayers." And that statement should read, "One of the primary rationales for use of the SFAS 143 method for regulated utilities is that customer payments for estimated net salvage represent a loan to the company from ratepayers." There's a minor change, but I intended to address the use of SFAS 143, not the purpose of SFAS 143 as it was issued.
And you said that's based on a company's data response?
I realized the error of my phrasing in as the company requested clarification in their data request to me set 1 to OPC question 3, part A. And in my response to that, request, I made the clarification, but I would also like to make the correction for the record.
Any objection, Mr. Collins?
No objection, Your Honor.
Any objection, Mr. Wilson?
No objection, Your Honor.
Okay, Your Honor, with that comma, I just have these things. If you were asked the same questions today under oath as were posed in your pre-file testimonies, Mr. Guerin, would your answers be the same, say, for the corrections that we made?
Yes.
And for these reasons, do you adopt this direct testimony along with the exhibit and your correction as your sworn testimony in this matter?
Yes.
Your Honor, I would respectfully move that OPC Exhibit 6 be admitted into evidence in the record of this case. And while Your Honor said that she has no questions, I just would like to say that I turn over Mr. Guerin to you and the other parties.
Okay, his direct was marked as Exhibit 7.
Oh,
So would you like 7 entered into the record?
Oh, yeah,
It's
no,
before...
no, 7. Jerry's last one was 6. I forgot to write it down on mine. Thank you, Your Honor.
Okay. OPC Exhibit 7, Mr. Guerin's direct testimony as corrected today will be entered into the record as OPC Exhibit 7. Mr. Alexander?
Yes. Yes, Your Honor.
The term sheet that was referenced and discussed a little bit today, it's my
Yes.
understanding that OPC has agreed to the provisions contained in that term sheet. Is that correct?
Absolutely, without qualification.
Okay. Mr. Collins. Oh,
And
yes.
if I may, Your Honor, I just want to say that all of the parties are working expeditiously to finalize the settlement agreement upon which that will be based on the term sheet. And we already have received a draft from Columbia. We have, I believe, the rate states, but not the tariffs yet. And we are reviewing, and staff is reviewing right now the full settlement agreement, and we'll make any negotiations. But we are all acting cooperatively and with as much speed as we're able to do with our respective managements. And I thank Your Honor for your patience and your guidance, because it'll be worth getting there, but it's been a little rough ride. I appreciate it.
And you understand what I said earlier, that if between now and actually not right up until the hearing on Friday, you may file written testimony in support of the settlement, or you can have any witnesses you care to appear on Friday to orally support the settlement as you deem necessary based on your...
Absolutely. Right now, we're contemplating at least our revenue requirements witness, Lafayette Morgan, filing a brief written testimony in support of the settlement. But I don't know the schedules for the 18th, but we will be requesting all of our evidence, all of our witnesses to be present, and that depending on anything that happens, we may call them, or you will be welcome to call them as well, or any of the other parties. Is that satisfactory to you, Your Honor?
It is to me. I assume it is also to Mr. Collins and Mr. Wilson. Is that all for OPC today?
Actually, Your Honor, if we could go back to Mr. Morgan, while he did not file rebuttal testimony, he did file a corrected direct testimony. So there are 2 exhibits for Mr. Morgan. OPC 3 and 4. 3 is his direct testimony that was filed on July 24th, and 4 is the corrected direct testimony on a couple of items that was filed on August 10th, 2020.
Okay. Mr. Collins and Mr. Wilson, do you have any objection to corrected testimony of Mr. Morgan being admitted as OPC Exhibit 4?
No objection, Your Honor.
No objection.
Thank you. So OPC Exhibit 4 will be entered into the record again. That is Mr. Morgan's corrected direct testimony.
That's correct. Thank you.
Is that it for OPC now?
Yes.
Okay. Mr. Collins, I have one last request.
Yes, Your Honor.
From what I could tell today, from testimony today, the parties are agreeing to a discount factor to be used in stride proceeding and in a make whole, although Mr. Tubbs testified that it would be unlikely. My understanding of the testimony is that the depreciation in the next case, what the parties are agreeing to is that the company will use the SFAS 143 methodology, but that the parties are sort of maybe agreeing to litigate the appropriate discount factor in a future case. And that's fine with me. I just think that could probably be more clearly expressed in a formal settlement agreement than I find the term expressed in the term sheet. Is that?
Yes, Your Honor, we understand that observation and concern. We can be more specific, and we will be happy to circulate our proposal for greater specificity to the parties for their review, and we'll have that included in the final signed agreement. Of course, that's our aspiration, but we do understand your concern, and we will address it.
Thank you. It's hard to approve a settlement that has language like an appropriate discount factor without knowing what the parties mean that to mean. Okay, I think that is all I have for today. Of course, the record will be kept open to admit into evidence the formal settlement agreement. Are there any other questions or anything else we need to deal with today?
Your Honor, one question regarding court reporting, if I may.
Yes.
In the event that we would like to request a transcript of today's proceedings, how might we contact the court reporter for us and for any other party to access that information?
Eddie? Hi. Can you talk to Mr. Collins?
I certainly can. Mr. Collins, would you like to have the email address or a telephone number? Which way works best for you?
Why don't we start with email, if that would be okay?
Sure. It's info@crcsolomon.com. And you can just request your transcripts on there. If you'd like the phone number?
Yes, please.
I'm looking that up very quickly for you. It's area code 410, of course. 821-4888.
4888.
Yes, sir.
Thank you so much.
Yes, sir. And Judge?
Thank you, Your Honor.
Anything else from anyone?
I do, Judge, but we can do this off the record with a little sidebar if you'd like for some housekeeping, okay?
Okay, I'll stay on.
Thank you.
Okay. As I said, this hearing is continued to next Friday, September 18, beginning at 10 a.m. I will send out a new WebEx invite to counsel, and they can forward it on to who they think they would like to have appear. Okay.
Your Honor, if you're anticipating questions to any of our witnesses, will you let us know so we can make sure that they're there?
Yes, if you are able to get a formal settlement agreement filed in time for me to review it in time to let you know, then I can, yes. You know what I mean? If you file it pretty late in the week, then maybe you just need to have everybody on standby. But if you get it filed early in the week, as Mr. Collins aspirationally mentioned, then I will have time to fulfill your request.
Well, we certainly hope to do that.
Thank you.
And Your Honor, if I may, just to let the parties know about one arrangement for next Friday. The safety and reliability, the final update, we will be forwarding along to the parties for their review. We'll be doing the same with expenses. Our target date is on or before next Wednesday, September 16th. So we'll be in touch on both of those fronts. So please look for that information, which will be forthcoming as quickly as possible, no later than the 16th.
Anything else? Okay, this hearing is continued. I'm going to stop recording.
Thank you.
Thank you.
Thank you all.
Thanks, everybody.
Thank you.